Hi, you guys. Hi, everyone. Thanks for joining me. Okay, so I'm going to get started right away because I don't want to have too much of a delay. So what I'm doing, hi everyone. What I'm doing is that after being convinced by several people, I have finally decided to start a YouTube channel. And it's something that I've fought a long time, 2 years probably. And the reasons why I fought it are that um, I am not very comfortable in the front of the camera, as you all know, since I just started doing live videos in here a few weeks ago. And I'm not very thick-skinned. I don't know. It's very hard for me to talk in front of people. And I always felt comfortable in here because I've known you guys for a while and everything, and I know that it's kind of safe to talk in here. But what's been happening is the reason I've been doing the videos is because there's been a lot of material to cover. And I was hoping it's easier for you guys to understand, but I was also hoping that it would take away a little bit of the stress off of me so that I wouldn't have to answer so many questions and be typing for 6 hours straight. But the problem is that the last several videos I've done a video for an hour talking to you guys, and then I have proceeded to go and answer questions for the next 6 hours in the other groups. So I found out that, and again, this is just because I just started doing this, but I found out that you actually can download a live video after you do it. So I decided that what I'm going to do is that after I do my live videos in this group, I'm going to download them and upload them to my YouTube channel. And that way they can be shared in the other groups, in whatever groups, or even on Twitter, whatever, where everybody wants to share it. The only problem that I had was that I didn't want to do just YouTube videos because I really like the immediate feedback of doing the live video. It feels a little bit more conversational to me, and I don't feel so much like I'm just talking to everybody and just unloading a ton of information. And I like that you guys ask questions, and I can answer your questions right away as I'm going, because I don't always think of everything that that you might want answered. Thank you. So, but I still want people to stay in this group, and I want people to feel like this group is where, there's something special about it. So in that respect, that's why I want to keep doing the live videos in here, let you guys ask the questions, and hopefully if anybody's watching on YouTube, they will have the same questions, and then I will be answering it for them as well. I know, I'm hoping people will be kind. So I am going to let you guys have to listen to a little introduction here, and I'm sorry, but I have to do this for people who are new and are just joining me for the first time. Okay, so I run a Facebook group called Basically a Lawyer. Now, Basically a Lawyer is a joke. Okay, I mean, I took some heat for that before. It is just like somebody saying like, well, basically I'm a lawyer. Okay, so it's a joke, it's tongue in cheek. I am not, capitalized, N-O-T, not a lawyer. I do not give legal advice. I'm not an expert on the law. Okay, I just want to make sure that that is very clear. My background is in criminology and law, and I was also a private investigator. So I did a lot of work investigating, but I do have a background in criminology and law. And the way I came about having this group is that I found out when reading all the documentation in the case that it was surprising to me how many people really didn't understand a lot of the court documents. People can understand the trial documents for the most part, and some stuff is confusing, but they can understand the CASO report. But when it comes to reading the actual motions and anything that's filed with the court, it can be difficult for some people to understand. And so I just kind of stepped into the role of just helping people understand it. I've been told that I'm very good at explaining things in a non-lawyery way, that I can explain things in layman's terms. And so that's all I'm hoping to do. And then that was all I was hoping to do, was just help people better understand what all these legal things are saying. Because we all know that lawyers can take 100 pages to say something that would take 10 minutes for a normal person. And then from there, I mean, people started asking me about procedures, about laws and statutes, and especially in the federal court system with EDPA and everything. And that's really where I got started in really talking a lot about the legal stuff, was because it is hard for anybody to understand EDPA or AEDPA because it's stupid. It really is. So I spent a lot of time trying to explain that to people. And then again, like I said, from there it just kind of snowballed. And then I started delving into case law because we see these documents, as everybody probably knows by now, you will see lawyers making arguments and they always sound good. Like everybody makes their case sound good, but then you start delving into the case law and you find out that maybe the case law doesn't really support the argument that great, or maybe it does support it really well. And that was the thing that I really wanted to help people understand. No, I am not from Manitowoc. No, I am not. And I'm not saying your names when you're saying hi. Usually I say hi to everybody, and I don't know how comfortable people are with that on YouTube. So I don't know. I was kind of hesitant to do that. So you let me know. But I totally lost my train of thought there. So anyway, now for those who don't know, I am a supporter. Okay, I am very much what you'd call a truther. Okay, and I think a lot of the people who I have talked with that are guilters would probably agree, though, that I am very much about the facts. Very much about the facts. I do not skew information or skew the facts just to help my own argument, help support my own argument. I won't do that ever. And the same is true when I'm discussing the law. The law is the law. Laws are black and white. Either case law supports your argument or it doesn't. Either your argument's good or it's not. Either something is a strong claim or it's not. It's just, I mean, granted, everything here is my opinion on those things, but I don't add anything to it. I don't add my own slant on things just so that I can say that, yes, it's a great argument, that Kathleen Zellner made the greatest argument that was ever been made. I have actually been accused of being a Zellner basher from time to time because I have been critical of some of the mistakes she's made. And I don't do it to bash her. I don't do it because I don't think she's capable of doing her job. But again, when I'm talking about things from a fact point, perspective, I have to call them like I see them. And if the state does something that's a good argument, I'm going to say it's a good argument. If Kathleen makes a bad argument, I'm going to say it's a bad argument. If the state makes a mistake, I'll call them out on it, but I'll also call Kathleen out on it. I try to stay very middle of the road when it comes to describing all of the legal issues. I've also been called a Debbie Downer on occasion. And that's because whenever something is filed, everybody always wants to believe we're going to win, yay, and if I don't think it's going to go a certain way and people ask my opinion, I'm going to tell them the truth. I'm not going to sugarcoat it. I know I did attend the en banc hearing, oral arguments in the Seventh Circuit, and the second I walked out, people asked me there what I thought, and I said it's going to go 4-3 against. I just knew it. I mean, I think it was pretty obvious from the oral arguments that it was going to be at least 3-3, and then considering that Easterbrook didn't say anything, I knew it was going to be 4-3 against, because Easterbrook, if you know him and you know his stance on EDPA, there really was no chance he was going to rule in Brendan's favor. But some people didn't want to hear that. Some people said, you should be more optimistic, or you should be, giving out more positive thoughts, or you should give people more hope. I don't do it to destroy people's, hopes and dreams, okay? I say the things I do because people ask for my opinion, and I give them my opinion. And I'm very clear that it is just my opinion. If you have a difference of opinion, I respect that, okay? So that's just something to know about me, is that I call things as I see them. I don't necessarily want to take the wind out of anybody's sails or anything, but I speak the truth to the best of my ability. The one thing I do want to say, though, is that I'm human. I make mistakes. The law is a complicated little beast, and lawyers have a hard time understanding this stuff. There's a reason that trial lawyers aren't appellate lawyers. It's very complicated. And so I do misinterpret things. I do make mistakes. I try very, very hard not to, and I actually feel terrible when I do. but I will always correct myself. I will always correct myself as soon as I can, or as soon as I realize it, and trust me, I feel horrible when I do it. But I always correct myself. And I said, I try not to do it, but I'm human. It happens. Please be kind. You know, I'm not trying to win any over any fans or anything like that. I'm just me, and I'm just trying to help people understand things. And I do have guilters that are in my group, and none of them have given me any trouble because they appreciate the fact that they would like to understand what legally is happening just as much as any supporters do. And they don't give me any hard time. And that's all I'm doing is just trying to help people understand the system, what to expect, what's going to happen next, explaining some of the complicated laws and things like that, you know. And I don't allow any fighting in my group, and I don't allow people to be mean to each other. So it works out fine, you know. And I think that most people just want to know what's happening, even if you maybe don't agree with my actual opinion on it. That's just the way I do things. Okay, so hopefully that's enough of an introduction. If not, oh well, I'm trying here. You like just me. Thank you very much. Now, when people do ask questions when I'm going through the video, I will try as much as possible to actually read the question, because the questions and the comments won't be showing when I upload it to YouTube. So I want people to understand what I'm talking about. And if I forget, somebody just remind me and I will do my best. Okay, so I am going to be rehashing some of the stuff I talked about in my previous videos. I'll add a little bit of new stuff, but I just want to make sure that everybody has a good handle on this, because there still were a lot of questions last time. And since this is going to be reaching some different people in the different groups, I do want to make sure I cover everything. So again, we're going to start with Brendan's case. Okay, so this is a big week for Brendan, and I think everybody is aware of that. For people who don't know, the U.S. Supreme Court is going to be having their conference on Brendan's case on Thursday. Now, the conference is where they discuss the case. This will be their first opportunity to discuss it as a group. 3 things can happen after this conference. Okay, they can either grant certiorari, and which means that they are agreeing to hear the case. They can deny outright the petition, which means that Brendan's case would be done in federal court and that the 7th Circuit decision would stand. Or they can relist the case. And I know I've covered this before, but when the case is relisted, that just means that they are adding it to another conference. Do not panic. If you're a supporter, do not panic when that happens. It's actually a pretty good thing. Last term, the Supreme Court actually didn't grant cert, I think, in a single case where they didn't relist a case at least once. It was one of those things that they always said, oh, if they don't relist it at least once, that's a bad sign. So if they can deny after relisting, they can grant after just one conference. But in general, if they decide to discuss a case for more than one conference, it's not a bad sign, you know. So let's see. Now this Thursday, they actually have, I don't know what the court is doing right now. They are so behind. They really are. I believe they still have 21 cases in front of them that need opinions, and they have not granted a petition in several weeks. And they have, I believe there's over 20 cases that were relisted just from the last conference last week. And now they have added cases like Brendan's are going to be added to this conference. So there are a lot of cases to cover. Now, the court did add an additional day for opinions, and that's on Thursday morning. So that's before the conference, but that's just for opinions. They have not added any extra days announcing orders as of yet. Now, they can spring them on us sometimes, but for the most part, everybody should count on having to wait until Monday until they release orders. I know it'll be a long weekend for some people. And they said they could spring some orders on us prior to that, but as of right now, there's no official added date to release orders. Now, as I said before, there's only one conference left after this one, so, but it is possible, again, being end of term, that they can add additional conferences, especially since they have so many cases to get through. Some of those 21 cases will be held over. The Supreme Court does their best to try to render a decision in cases that are argued in that term, but sometimes it's just not possible. And there are a couple cases that have been relisted. There's one case that's been relisted like 13 times already. So, some cases are going to be held over. We're hoping that it's not Brendan's, because then you have to wait all summer to find out just if it's going to be heard. And that would be really hard. That would make for a very long summer. So okay, I'll start with if it's denied. Okay, if the petition is denied, as I said before, it's done in federal court. Okay, he can't bring it, back again. Okay, so what would happen next for Brendan would be that his best bet would be to file a petition for post-conviction relief in the state court based on newly discovered evidence, if he has any. Now, we both know that, or we all both know, just all two of us, we all know that that's what Steve's case is at right now. He filed a petition for post-conviction relief in the state court, and it was denied, and it's in the appellate court right now, and I'll cover that a little bit later. But Brendan has the right to do that as well. And I know I've mentioned this before, but, oh gosh, as usual, the comments just stalled again. I have no idea what's going on. So if you guys are asking me, okay, wait, hold on, can they relist it without even discussing due to being overbooked? Yes. Usually it will say it's rescheduled if they don't get to it at all, but they can relist it. And I'm sorry if I missed any other questions. Again, my comments stalled. So, but yes, they can relist it without just discussing it all. Like I said, usually it's rescheduled, but they can relist it. So the one interesting fact about Brendan is that, for those of you that remember in the decision for Steve's case, that Judge Suckowitz had said that he was procedurally barred from raising a significant amount of the claims that he raised in his post-conviction petition. And they say you're procedurally barred because everybody is supposed to have, the idea is that you want some finality in the court system. So you're only supposed to have one petition for post-conviction relief. They don't want people to keep filing successive petitions over and over again. So in order to keep people from doing that, they want everybody to make sure you have all of your information before you file your petition. And when Steve filed his petition pro se, which means he did it himself, that had been denied, and it was in the appellate court when Kathleen Zellner came on board. I am still a little unclear as to why she didn't at least try to maybe get it kicked back down into the circuit court as is and just add to it as opposed to starting a whole new proceeding, because she wouldn't deal with this procedural bar right now. But I don't know. That's just something that I kind of tossed around in my head one day. If she could have done that, I don't know why she couldn't have. But the problem is then, once Kathleen filed her new petition and dismissed the other one, that raised this procedural bar issue. Okay, they're essentially saying Stephen waived his right to bring up those issues because he didn't bring them up before. And of course, Kathleen is arguing that he was a pro se appellant, and how can he possibly be expected to be able to do what she is doing? Whether that argument will work or not, we'll see. But the interesting thing is that Brendan has never filed a petition for post-conviction relief, otherwise known as a 974.06 petition. Brendan has never filed one, so he is actually not procedurally barred from raising any newly discovered evidence claims. So that could lead to some really interesting outcomes, but we'll see what happens, and I don't want to get into that too much because we're hoping we don't go there. So, but that's what his options are if the petition is denied. Obviously, if the petition is granted, that's a whole different area. That means it moves forward in the Supreme Court. And what happens when a petition is granted is that a whole new set of briefs are filed. They enter what's called, they're out of the cert stage and they enter what is called the merit stage. Generally, 45 days after the decision is made to grant cert, that is when the petitioner's merits brief is due. That would be, I actually wrote down the dates, assuming nothing, they make a decision on Monday, August 18th, they decide to grant. We're looking at an August 2nd due date for a merit brief from Brendan's team. Amicus briefs that are in support of Brendan or in support of neither party, and you might ask, why would somebody even say anything if they don't want to support either party? Sometimes people have an interest in the case, but they don't actually have an interest on either side. They just want to be heard. And so it does happen. So if it's somebody that is supportive of Brendan, in support of Brendan, or support of neither party, they have to file their amicus brief within 7 days after the petitioner's merit brief is filed. Brendan's brief is filed. Now, 30 days, and again, it's somewhat general in the Supreme Court. Sometimes they're a little lax on certain things, but they don't usually like to extend or grant extensions at this point. They will, but I mean, they don't like to do it at all at this point. But they could. But the state has 30 days to file their respondent brief. Okay. And just like with amicus briefs for the petitioner, anybody that is in support of the state has within 7 days to file their amicus briefs. Why refile in the merit stage if they've already been filed in the petition stage? The petitions are going to be, they're a little bit different in the petition stage. Well, first of all, nobody filed in support of the state, which isn't uncommon. You know, I mean, if you want to break it down into its simplest form, in the cert stage, both the brief of the petitioner, or you know, the petition itself, I should say, and the amicus briefs are telling the court why they think that this case needs to be heard. They're saying you should grant cert because, and then this, you know, is the reason. The briefs in the merit stage are not much different. The only big difference is going to be that any amicus briefs that are filed are going to say, this is why Brendan Dassey should win, or this is why the state should win. This is why you should rule in favor of the state, or to be technical, affirm the lower court's rulings. So it's just in the cert stage, you're telling them why they should hear the case. In the merit stage, you're telling them why the person you're supporting should win it. That is really the biggest difference. I mean, the arguments are essentially going to be the same, but you will see more. You will see more amicus briefs in the merit stage. More people get interested once they know the case is actually going to be heard. So there should be, you know, I don't know how many more, but there will be more, and the state will have support at that time as well. So let's see. Then obviously the petitioner has the opportunity to file a reply brief, which is usually about 30 days after the respondent brief. That's pretty much, you know, it's pretty standard, not much different. They have 45, you know, Brendan has 45 days to file after the petition is granted. That's really the only longer date. Now, I've talked about this before. Now, the court itself can call for the view of a solicitor general in the cert stage. And they can probably call for him anytime they want, actually. But they usually do it in the cert stage. But the solicitor general can take it upon himself in the merit stage to file a petition in support of either party, neither party, both parties, whatever he wants to do. And I know I've mentioned this before, that the solicitor general is the only person who doesn't have to ask permission to file an amicus brief. The court has to accept it. So that would be due just like the other amicus briefs are due. There's no difference there. But the solicitor general, or any amicus party actually, can also, with permission of whichever side they're supporting, ask to be heard on oral arguments as well. They can divide the oral arguments with the actual attorneys representing each side. So, well, now again, going by if the cert is granted on the 18th, the reply brief would be due around October 10th. That's the date I just came up with, but around that time. Oral arguments. Now, based on the number of petitions that have been granted as of now for next term, I believe we're looking at an early November or early December argument date. They are actually very close as far as the number of cases that they've granted at this point in time. But last year they granted quite a few petitions at this point in June. Like in the last week or two of the term, they granted, I think, 8 or 9 petitions. So that's probably what they're going to do again. And again, that would put Brendan's case somewhere in late November, early December. There are fewer argument dates in those months because of the holidays, but it should still fall into that. Usually what happens is that if your petition is granted prior to the end of term, your case is going to be heard in the first part of the term in the fall. And if it's granted not until the big day for orders in the fall, usually your case is going to be argued after January 1st in the second half of the term. Again, doesn't always happen that way, but that's usually how it works. So hopefully, you know, if Brendan's case gets held over until a decision isn't made until October, well, then we're talking about orals much further out. Now, I know I've mentioned before, again, I keep saying that, I'm sorry. But the briefing schedule does not change just because the court is no longer in session. They're not sitting anymore. Briefs can still be filed and all that can still happen over the summer, which is good. Like I said, the reply brief would be filed in the fall, and then it would be perfect timing. Is this Brendan's last hope? I actually answered that. You're going to have to probably go back and watch because I don't want to repeat it for everybody. But I actually did just answer that a little bit. No, it's not his last hope, but it would be the end of his case in federal court for now. So where was I? Okay. So if oral arguments are held in November, December, again, probably will take 4 to 5 months for a decision. If anything, there's really no reason why the court wouldn't have an opinion by the end of next term. So again, if you're a supporter like me, then the best case scenario is that Brendan's conviction could be overturned by next June. Best case scenario. Obviously, things can happen in between there, depending on what happens with Steve's case and what Kathleen has going on and everything. But I'm just going by what we already know to be true. Okay, so yeah, that's okay if you're late. That's fine. Like I said, you can just always go back and rewatch that part, the part you missed. No big deal. So, does anybody have any questions about Brendan's case? I think I answered everything that I was asked previously. And I don't know if I said the comments are just loading weird again. I did that last time too. I don't understand why I'm having such an issue with that. So here I am saying that I want to answer all these questions in real time and I want everyone to be able to see it. And then no, I'm seeing no questions because no comments are coming up. I'm going to scroll back to see if there's anything else. I think that's it really for Brendan's case. And I should say right now that this is going to be a little shorter than I planned, because when I actually wrote an outline, which everybody knows I never do, I usually just wing it, and I figure, well, if this is going to be my first YouTube video, I should probably have an idea of what I'm talking about. Oh, stop. I'm not answering that question. I had written up what I wanted to discuss, and first off, it would probably take too long, and second of all, it probably isn't the best introduction for me for YouTube, and not because of why people would think. It's actually discussing, I have this big discussion on the Brady motion, on the Brady violation, and honestly, it would make supporters a lot unhappy than it would guilters. So probably not the best introduction. Nobody's going to want to watch my channel because they think that I'm the worst supporter ever. But it would go to prove what I said in the very beginning, that I just report the news. I just report what the court's doing. I don't really, I can't help it. So, but I think I'm going to probably hold off on that. So this is actually going to end up being a lot shorter because I had a whole section on it, and I had a lot of discussion on it, and I just don't know if that's really great to discuss for my first video. Okay, so we are going to move on briefly to Steve's case. Okay, and yes, I agree, American law system, hurry up and wait. But with Steve's case, the one thing I just am constantly reminding people, again, gosh, I hate doing this, but I mean, why has it been delayed? Why have there been so many extensions? It's not the state. I mean, I hate to say it, but it's not. I mean, it's been Kathleen, so we really can't complain so much about how long it takes when his own attorney is the one that keeps asking for extensions. So I'm just saying, please don't hate me. It's just what I'm saying. I know. I wish it was all over with too. That would be nice. So we're gonna move on to Steve's case. Now, I didn't really get to talk about this a lot because the decision came down when I was in Manitowoc for the rally. I'm gonna say your name, Tiffany. Stop it. Behave. You're killing me right now. Okay, so I didn't really get to say much. I posted the screenshot of the court docket with all the orders from the Court of Appeals, and as I'm saying, like, I kind of mistook something, and I'm not going to completely take the blame for that. I mean, it is my fault, I guess, but I really got stuck where it said, when the Court of Appeals used the words that, and don't quote me on this because I don't have it written down exactly, but where they said that, that they could evaluate the CD, the discovery issues with the CD, or any other new information. Okay, what does that sound like? It sounds like any other new information. Now, I think we all know by now that supposedly Kathleen Zellner has new evidence, and there has been a bunch of talk all over the place about how can she present new evidence in the Court of Appeals. Well, she can't, okay, but she's going to try. And I don't understand that. I don't understand why. If anything, thank you. I love you guys too. Thank you. If anything, this decision just proves that if they're going to remand the case to get this CD properly evaluated in the circuit court, there's no way they are going to allow any other evidence, new evidence, to be presented in a brief. It's just not going to happen. And so I don't quite understand the thinking of getting it remanded. I mean, this wasn't her choice. She obviously wanted the CD to be added in the Court of Appeals, which I thought was a possibility because it was a supplement. But I actually did say that early on. I said that the worst they can do is remand it because the state's biggest argument was that it was new evidence. Well, fine. If it's new evidence, then remand it and then get it in. It really wasn't really a case of it going to be denied and they flat out weren't going to let the CD in. Now, that could happen in the circuit court. I will get to that later. But I don't understand the point of remanding it, especially when you're talking about 30 days, and I don't have the whole order written down right now, but 30 days for her to file her brief and 60 days for the judge to make a decision, 15 days for the statement on transcript. Then the record has to be compiled and sent back again. And what could actually happen is they made a big deal of saying that Kathleen Zellner has 6 days to file her brief after it's back, after the briefing schedule. I'm probably talking really fast, sorry. After the briefing schedule has resumed, Kathleen Zellner has 6 days in order to file her brief. And I know it's been floating around that it's 4, and that could be, it just depends on what day it falls on. But she technically, legally has 6 days. Okay, but if it falls on a weekend, or like if it falls like on a Thursday or something, well, obviously she's not gonna be able to file it on a weekend. So she's going to file her brief, and if in that brief, she's gonna try to present a bunch of new evidence, what is going to happen? They're going to remand it back to the circuit court again. And she may even specifically be asking to remand it. But I just don't know why she's not trying to get that all taken care of right now. Because Kathleen's tweet was very clear that, and and the Court of Appeals did say that. They said, it's going to be added back to, or brought back to the Court of Appeals after the record has been completed or whatever they do with it. And they're going to resume briefing. But I don't think that the Court of Appeals necessarily knows she's going to try to present new evidence in her brief. So now, as people are saying, hurry up and wait, hurry up and wait. Well, again, this is a situation that I think could be done quicker in a different manner. Okay, cue all the hate. I spoke with her, yes, and after talking, we think there's more coming. Yes, there is more coming, which is why I'm sitting here thinking, why is she just not having it, asking or adding everything now and get it evaluated all at one time? Oh my gosh. Okay, last time we got really lucky. Last time we got really lucky because my dog didn't bark at all, and of course she picks now to do it. So, this is gonna be terrible. I'm so sorry. Okay, this is great. I'm gonna have to, oh gosh, I'm so sorry. Of course she does this now. My sweet little angel. Yeah, her name's Justice. Yay. And yeah, she's not being very good right now. Anyway, what was I saying? Oh yeah, so Kathleen is gonna remand it. If it was gonna be, be nice to my puppy. Tell her to shut up. If it was gonna be remanded, I don't know why Kathleen wouldn't just throw it all out there, have it all evaluated, because there's always the chance that seeing new evidence that Judge Suckowitz could grant an evidentiary hearing and no longer need this appeal. Now, before everybody jumps all over me and says, oh, there's no way that she's going to rule in Steve's favor after last time. Okay, let me explain something. Everybody knows that, occasionally I talk about the Adnan Syed case. In that case, the trial judge, Judge Welch, also presided over Adnan's post-conviction hearing. And Adnan filed his petition for post-conviction relief, and it was denied. It went to the Court of Appeals, and there was new information presented. Now, in that case, Adnan's lawyer did ask for a remand back to the circuit court to evaluate this new evidence. the Court of Appeals ordered the judge to evaluate this new evidence. And after the new evidence was presented, the same judge who presided over his trial and had decided that he was going to deny his post-conviction motion granted an evidentiary hearing. And after the evidentiary hearing, he actually overturned his conviction. So it can be done. So people always say I'm negative, and yet I'm seeing people saying, no way, there's no way this judge is going to do anything. You don't know that, okay? Sometimes it's based on what's presented. You just don't know, you know, so, and who knows? Who knows what she'll do with it? We don't know what's being presented. Well, in this case, we know it's a CD, and I don't see why that can't be added. Especially at the trial level, there's really no reason, or at the circuit level trial level, same thing for people that don't know, that's the same thing. There's no reason it shouldn't be added. If you're adding it at the trial level, there really is no reason why it shouldn't be added. So I'm just throwing that out there so people know that, you know, just doesn't automatically mean she's going to deny this or deny anything else. I don't agree with her ruling, but not for the reason that most people don't. I just don't agree with it. I think procedurally there's issues with it. That's a topic for another time, though. So let me see what else there is. So once that CD gets evaluated, they come back to the to the Court of Appeals. Then, as far as I know, she's going to file the brief and she's going to try to present new evidence, and it's going to get kicked back down for remand again. And then we're going to go through this all again. That's the only way I see it happening. I don't know any other way that it can. And maybe somewhere along the way, there will be a way for her to present it all at one time. That would be really, really nice. But that is where that stands as of now. This is a great introduction. Thank you. Thank you, my lovely dog. So this is where I was going to move into the Brady violation itself and discuss some of the issues with that. But as I said, probably not the best introduction because some people might really dislike me. So right now, if there's any other questions, and I don't think I'm getting all the comments, anything that has been discussed with Casey could be part of the investigation. Oh, is that your... Okay, that's your disclaimer for me? Yeah. Okay, so are there any other questions? This has been, no, it's a Chihuahua, not a Pugwalla. If anybody doesn't know the story behind how I got my dog, okay, she actually is an Avery. I know, don't turn the channel, okay? Chuck Avery, who is Steve's older brother, he has Chihuahuas, and his pups had a litter of 5 little Chihuahuas. And Carla sent me pictures of these cute little puppies, and I never in a million years thought that I would own a Chihuahua. And yet she kept sending me pictures every day, and they were so cute and so sweet. And so, then I decided I had to have one. And of course, I have the mean one in the litter. She's a sweetheart. She's my angel beast. She's sweet half the time and really a beast the other half of the time. But, and of course, I named her Justice because, you know what, to me, no matter what, even if I thought Steve was guilty, and I know a lot of people may say this, but everybody knows me, knows that I mean it. Even if in my heart, like in my gut, I thought that Steve was guilty, I would still think he deserved a new trial because that investigation was a joke. That is my biggest problem with it. You know, it's not so much, you know, the actual, I don't know. I just think that it was completely mishandled. And again, my background's investigation, my daughter's, you know, in forensic investigation. And, you know, it's like we know what's right and what's wrong and when things are handled right and when they're not handled correctly. And I think the only reason that people have a problem with it other than just thinking he's guilty is just because, you know, they don't want him out, you know, and I just don't think that's right. I think that if you believe in justice and more importantly, truth and justice, even if you think somebody may be guilty, you know, if it wasn't done the right way, that it has to be. It has to be. You know, one way or the other. I think that this case needs to be, just needs to be handled correctly without all of the procedural mistakes and the investigative bias and that, you know, and that's my big stance on it. So, and I am 100% being honest, like I said, and anybody who knows me knows I'm telling the truth, even if I thought he was guilty. I might begrudgingly say that he deserves a new trial, but I would still feel that way just because of how bad I think the investigation was handled. I might not be happy about it, but okay, I saw somebody ask a question somewhere. I don't turn the channel. No, she's a sweet dog. She really is. She's just maybe a little naughty sometimes. Hi. Okay, thank you. I'm sorry that usually there's so many questions I can't even keep up. I thought I saw one that I missed somewhere, but now you guys are just talking about dogs. So, and yeah, like I said, it was the perfect name. I couldn't even think of another name because I am such a firm believer in justice in every aspect of the system. Do I know what the new evidence is? Okay, next question. Um, if you can't add new evidence, how was he exonerated in the first case? Well, it was introduced in the circuit court, which is how you have to introduce new evidence. It's not that you can't introduce new evidence; it's that it can't be introduced in the appellate level. And I mean, I thought, I think I probably covered this before, but okay, the basic reasoning is that the appellate court is a review court, a court of review. Okay, they don't have witnesses. They're not set up for that. Okay, the trial court is set up for that. That's how they were designed. And this is how it's been since about I think it's 1976, I think. Because previously, the Court of Appeals and well, actually, there was no Court of Appeals. There was just the Supreme Court. And so then I think it was in 1976 that they developed a Court of Appeals. But then what was happening was that you were seeing all these post-conviction motions being filed in the Court of Appeals. And again, they wanted that to be an intermediary court, not a trial court. So that's when the 97406 was created. And a lot of states have a state habeas petition. We have that too, but the habeas petition has essentially been replaced by the 97406. The only time you really file, or the biggest reason to file to file a state habeas claim is if you're going to file what's called a Knight petition, which is ineffective assistance of appellate counsel. Okay, ineffective assistance of trial counsel and post-conviction counsel, which are both in the trial court, are filed in the trial court or the circuit court. But if you're going to file an IEC claim against appellate counsel, then you file it in the Court of Appeals. That's usually when a habeas petition, and sometimes it's called a Knight petition, but it's really a habeas corpus petition. And instead, otherwise, for newly discovered evidence, we use the 97406. And that's how we do it in Wisconsin, in case people are wondering. So somebody said to go into the Brady stuff. I really don't want to. I really don't want to right now. I wrote all this stuff up, and I had actually talked to several people about this. So I had all the case law and everything, and I just want to make sure I had it all covered. And then when I actually read through it, I was like, oh my gosh, my own group is going to hate me. The supporters are going to hate me for saying this, because all I'm going to say is that it's not a slam dunk, not even close. It is not a slam dunk decision. So that might just be enough for people to turn me off, but it's not. I mean, very few claims are a slam dunk, and this one is not either. There's definitely some issues with it. So I just don't think I should really go into it too much in this video. So I figured it was just best to go through some of the procedures, some of the things I've talked about before, and I know this is boring for people who have been in here because I've covered this stuff before, but I just want to give people an introduction, and this ended up being not the introduction I wanted, but that's life. Who's asking if I chug beer? Why are you asking me that? Are you asking somebody else that? I do not. I don't like beer. I live in Wisconsin. I don't like beer. I'm weird. I know. Okay. Okay. Are there questions? Am I missing them? I keep coming back to that Brady one. Thank you. You're welcome. Okay. So, yeah, this is supposedly going to be my YouTube debut, and it's just not happening very good right now. But you know what? Whatever. I'm me. People don't like me. Oh well. I do my best. And that's all. I'll just finish up by saying, if there aren't any questions, what's on the jug in the desk behind me? Somebody asked me about my bowling trophy last time. Now someone's going to ask me about the jug. Pool shock. It's actually more hot tub shock, which I might have to go into after this. But God, you made me lose my thought again. My train of thought again. Yeah, I totally lost it. It's gone. I was gonna say something about my new channel, what I'm trying to do. Like I said, I don't know. I don't know if this is what I was going to say, but this is what I'm going to say, is that I don't I don't really have any ulterior motive. I don't really like arguing with people, um, which is why I don't. I haven't discussed the case itself too much at all lately, a little bit here and there, but for the most part, I don't. I just don't like arguing with people. And I really like doing the legal stuff, mainly because, there seem to be, people wanting it, and I try to explain things to people. I'm not trying to be anything I'm not, and again, I'm not saying I'm a lawyer or that I know more than any of the lawyers, because please, of course I don't. Actual lawyers don't know as much as appellate lawyers do, just like criminal lawyers don't know anything about patent law, or whatever. I mean, so it'd be impossible for me to ever think I know as much as lawyers do. But I'm just really trying to be helpful to people who don't always understand everything or want to know what things mean, or again, what the next steps are. That's all I'm trying to do, and nothing else. So, okay, so should we wrap it up, guys, for our debut? And I will save the Brady one for down the road. I'll come up with something else before then. You know me, I can always find something to talk about. Do I have a total head count from the rally this weekend? I believe there were about 50 people on Friday and maybe only about 30 on Saturday. I know, some people love debating. I have seen people in the groups that have been debating back and forth or even arguing back and forth since day one. I got tired of it after the first month. It's just not me, it's just like I state my position as clearly and as concisely as I can. I am very firm in my opinions on things, I guess, but I don't feel the need to have to argue with everybody. I respect, and I will say that I respect everybody's opinion, especially if you have an informed opinion. And I know plenty of people on both sides, and when I say both sides, that means those guilters too. I mean, that have read all the documentation. So how can I how can I not respect their opinion? It's an informed opinion. I wish people could be a little nicer to each other, but hey, that goes for both sides. I've seen nasty people on both sides of the fence, and I just wish people would be nice. So, okay. Okay, is there anything else? Quick, if anybody has any questions, say anything. And there really weren't a whole lot of questions. I know there were a lot last time, but that's because I talked about the same stuff. But hopefully I covered everything that should sufficiently answer questions. So yes, I'm going to be putting the YouTube link up. I know all the YouTubers say subscribe, subscribe, subscribe. Sure. It would be nice for people to subscribe, because I know there's some features that you can't use unless you have a certain amount of subscribers, some of the live feed and embedding live feeds and things like that. So it would be nice to have subscribers. I know they have a live feed option in YouTube. I don't know if I'm going to be utilizing that. I kind of like what I'm doing. So I don't know. This is totally a trial run just to see how it works. And if it fails and people hate me, then I'll just come back to my own group and do it. It's not going to change anything for me. So I will add the YouTube link, and so even if you've watched it, watch it again. Like I said, subscribe. I'll be adding it to different groups, or Angie can add it to the different groups, because Angie's my little helper. And I should say that in my and if you okay, I did turn commenting off on the YouTube videos because I need to just ease my way in here. So if you have any questions, you can join my group. The links at the bottom, will be on the description. And I do actually, my co-admin is an attorney. She's not a criminal attorney, but she's a very good attorney. And I have a couple other attorneys in my group. So we do have some people with some legal background, but again, they're not criminal attorneys, so sometimes they're just as confused about criminal law as I am sometimes. We just put our heads together and try to figure things out. Yeah, as usual, I'll the staircase, I'll get the chance to review. Well, okay, it's funny about the staircase, because now I'm totally going off track here, because I watched that years ago. And I know it's on Netflix now, so everybody's talking about it, and I know they've added additional footage. I just haven't, I haven't been home, so I haven't had a chance to watch it yet, but I will watch it again. It's been a while. It's been a couple years since I've watched it, so I will watch it again. But it's so weird for me to see everybody talking about it, and I was like, that was so 2 years ago. It is an interesting case, though. I agree. We'll ever talk about any other cases? I don't know. Maybe. I just know right now I only have time for this one. That's it. So, okay, I am going to end for now. I don't know when I'll be back. When I think of something to say that isn't going to irritate half the people watching, I will come back. So everybody, thanks for watching. and I will see you soon.